He smiled when they told him the jury was deadlocked. Not relieved, not grateful, pleased. Level 1. The Retainer. His name is Dale Mercer, and he doesn't look like what you imagined. That's the first thing you notice. You've been a defense attorney for 14 years. You've sat across from men who killed their wives, men who burned buildings down with people inside, men who did things to children that you had to read about in police reports, and then go home and hold your own kids like the world was ending. You know what guilt looks like in a room. You know the smell of it. Dale Mercer doesn't smell like anything. He's 41, an insurance adjuster from Naperville, Illinois. He coaches Little League in the summer. His wife, Karen, is sitting in the hallway right now, crying into a styrofoam cup of bad coffee, because she believes completely and absolutely that the man she married for 16 years is innocent. The charge is 1 count of murder. A woman named Bridget Calloway, 34, found in the forest preserve off Route 53. The prosecution says Dale knew her. Dale says he didn't. There's circumstantial evidence. A receipt from a gas station 2 miles from the scene. A single fiber from his jacket, which his lawyer, which you will argue proves nothing because your client jogs in that forest preserve regularly, which is verifiable, which is documented, which is reasonable doubt. You take the case for $40,000 retainer. Standard. Your firm handles 3 of these a year. You don't ask Dale if he did it because you stopped asking that question in 2009 when you realize the answer changes nothing about your job. Your job is the Constitution. Your job is the 6th Amendment. Every person deserves a defense. That's not a slogan. That's the architecture the whole system stands on. You believe this. You've believed it for 14 years. You go home that night, pour 2 fingers of bullet bourbon, and tell your wife Rachel you picked up a new case. She asks if it's interesting. You say it's straightforward. You believe that when you say it. Level 2. The File. 3 weeks into trial prep, your paralegal Jessica drops a box on your desk. Discovery materials, 600 pages of investigative reports, witness statements, crime scene documentation. You start reading at 8 p.m. You're still reading at 1 a.m. Bridget Calloway was strangled. Ligature marks consistent with a zip tie or thin cord. She was positioned after death, arms folded. That detail isn't in the news. The prosecution held it back intentionally, which means it means something to them. You write it down. You're a thorough attorney. That's why clients pay what they pay. So you dig. You run Dale Mercer through every database your investigator has access to. You're looking for priors, inconsistencies, anything the prosecution might use that you need to get ahead of. What you find instead is a missing persons report from 2019. A woman named Cheryl Odom, 31, who went missing from Joliet. The case is unsolved. Cheryl's last known whereabouts place her at a bar in Romeoville on a Friday night. Dale Mercer's credit card shows a charge at a restaurant in Romeoville that same Friday night. Coincidence? Has to be. Lots of people were in Romeoville. You close the file. You pour water instead of bourbon. You don't sleep well. Level 3. The knowledge. You know on a Tuesday in November. Not from evidence. From him. You're meeting at the county jail, prepping his testimony. Dale is calm the way still water is calm. Not peaceful, just without surface movement. You're walking him through the prosecution's timeline when he says something small, throwaway, a detail about Bridget Calloway that isn't in any report you've read, a detail about the way she was dressed that night, something no one told him, something he couldn't know unless he was there. You stop writing. He keeps talking.
You let him finish, and then you close your notepad and you say you need to make a call, and you walk out of the visitation room and stand in a hallway that smells like disinfectant and metal, and you understand with complete clarity what you are looking at. The rules are clear. Attorney-client privilege protects what Dale tells you in confidence. It protects almost everything. The exception, the one carved out by the model rules of professional conduct and recognized in Illinois, is future harm. If your client tells you he intends to harm someone, you can disclose. But past crimes, confessions, admissions, those stay buried with you. Dale hasn't confessed. He made a mistake. He doesn't even know he made it. And you can't use it, can't share it, can't call the detective on the Cheryl Odom case and say, "Look at this man, look at what I know." You are locked inside the privilege like a room with no door. You call your wife from the parking garage. She asks how your day was. You say fine. You go back inside and finish the prep session. Dale thanks you by name. He has very steady eye contact. Level 4, the trial. You are exceptional at your job. That's the tragedy of the next 3 weeks. You dismantle the fiber evidence in 12 minutes of cross-examination. The state's forensic expert is good, but you're better prepared, and by the time you're done, the jury thinks the fiber could have come from anyone who ever walked a public trail. You impeach the gas station receipt by establishing that Dale bought coffee there every Thursday morning for 2 years prior. Verifiable, documented, reasonable doubt. You put Karen Mercer on the stand, and she is devastating in her sincerity. 16 years. Little League. The vacation photos in Myrtle Beach. She believes every word she says. The jury can see that. The prosecution's case has a hole, and you found it in week 2 of prep, and you've been driving through it since opening statements. Their theory of how Dale knew Bridget Calloway is thin. Speculative. You say that word 17 times across the trial. Speculative. It lands differently every time. Your closing argument takes 48 minutes. You talk about the Constitution. You talk about the standard of proof beyond reasonable doubt, the highest bar in the legal system, and you say the state did not clear it, not even close. You believe the legal argument as you're making it. That's the worst part. You are not lying to the jury. The evidence really is thin. The case really does have holes. The system is working exactly as designed. The jury deliberates for 2 days. They come back with not guilty. Level 5, after the verdict. Dale shakes your hand in the hallway outside courtroom 4B. His grip is firm and dry. He thanks you. Karen is crying again. Different tears this time. Relief tears. And she hugs you like you saved his life. And in a technical legal sense you did. Dale watches his wife hug you and he smiles, and the smile has nothing behind it. Like a window painted to look like a view. They leave. You stand in the hallway until it's empty. You go back to your office and sit at your desk for a long time. Jessica asks if you want to celebrate. Some of the associates are going to Gibson's for drinks. You say maybe later. You don't go. Here's what you know. Dale Mercer is going to go home to Karen. He's going to coach Little League in the spring. He will be careful for a while, maybe a long while, because he's smart, and the attention scared him, and he knows now that he left something loose, some thread he didn't see. And he'll spend time examining his methods the way you'd examine a legal brief. Looking for the error, correcting it, making sure it doesn't happen again. And then, when enough time has passed and the careful feeling fades the way it always does, there will be another Bridget Calloway. Another woman whose name you'll read in a report that lands on someone else's desk. You can't prove that. You know it the way you know your own heartbeat. The rules that protected him are the same rules that protect everyone. The client who was innocent last year. The kid facing his 3rd felony charge who finally caught a break. The system doesn't sort. It applies. Uniformly. That's its strength and its cost simultaneously. And you have spent 14 years believing the strength is worth the cost, and you still believe that. Almost. You open your desk drawer. You have the notepad from the jail meeting, the one from the day you understood. You tear out the page with his detail on it. The thing he said that he shouldn't have known. And you look at it for a long time. Then you put it in your briefcase. Not because you can do anything with it. You can't. You know that. You put it there because throwing it away feels like the last wrong thing, and you've done enough of those this month. 6 weeks later, a detective named Roy Esposito from the Joliet PD calls your office. He's working the Cheryl Odom disappearance. He's checking in with everyone who might have had contact with certain individuals in the 2018 to 2020 window. Routine, he says. You say you appreciate the call. You ask him nothing. You volunteer nothing. You say goodbye and hang up and sit with the phone in your hand. Esposito is good. You can hear it in the way he asks the question. Not the question he actually asked, the shape underneath it, what he's really trying to find. He's moving towards something. He might get there, might not. The law is full of mights. Dale Mercer is at home right now. Karen is making dinner. Someone on the news is talking about a different crime, a different suspect, a different defense attorney sitting across a table from someone and asking questions and making choices about what to believe. The work continues. It always does. You open a new file. His name is Brandon Kowalski, and he doesn't look like what you imagined.